To understand why this ruling hit like a political earthquake, you have to go back to the core question the justices were asked to settle. The case centered on whether states have the authority to implement certain identification and verification requirements without running into conflict with federal protections embedded in the Voting Rights Act and the Constitution itself. For decades, this has been one of the most fiercely contested battlegrounds in American law. Supporters of stricter voting laws argue they protect election integrity and ensure that every legal vote counts. Opponents argue that burdensome requirements disproportionately suppress the votes of minorities, elderly citizens, low-income Americans, and rural communities who may face greater obstacles in obtaining the required documentation. The court had danced around this question for years, but this time there was no dancing. There was a direct, clear, and unanimous answer. What makes a 9-0 decision so politically significant is not just the legal outcome, it is the message it sends. When justices appointed by Democratic presidents and justices appointed by Republican presidents agree on something this politically charged, it forces both sides of the aisle to reckon with a legal reality they can no longer dismiss as partisan. The ruling essentially drew lines in the sand on what states can and cannot do when crafting their election laws. States now have clearer guidance on where their authority begins and ends, and that clarity comes with teeth. Election laws that fall outside these newly defined boundaries are now vulnerable to immediate legal challenges, with a much stronger chance of being struck down. The practical effects are already rolling in faster than most people expected. Several states that had recently passed aggressive new voting legislation are now facing urgent reviews of those laws. In some cases, provisions that had been upheld by lower courts are now being sent back for reconsideration in light of this ruling. At the same time, other states that had been hesitant to implement new security measures out of fear of legal exposure are now moving forward with confidence, citing the Supreme Court's language as a green light for certain reforms. The decision did not neatly hand a victory to conservatives or liberals. It handed a framework, and both sides are now racing to figure out how to use that framework to their advantage. Voting rights organizations across the country have already announced new litigation strategies based on the ruling. Some groups see language within the majority opinion as powerful ammunition to challenge photo ID laws, in states where obtaining identification is structurally harder for certain communities. Other legal scholars are pointing to different passages in the very same opinion to argue that states now have more room than ever to require proof of citizenship for voter registration. This is the fascinating and somewhat maddening reality of landmark Supreme Court decisions. They answer one set of questions while opening up a dozen new ones, and the courtroom battles that follow can stretch on for years. There is also a deeply human dimension to this ruling that gets lost when the conversation stays purely in legal and political territory. Real people's access to the ballot is at stake. An elderly woman in a rural county who does not drive and does not have an easy way to get a state ID is affected by these laws. A college student voting in a new state for the first time is affected. A naturalized citizen who has every legal right to vote but carries documents that certain officials may scrutinize more heavily is affected. The abstract language of constitutional law eventually lands on real people at real polling places, and the consequences of getting these laws wrong, in either direction, are consequences that democratic societies pay for in lost trust, social tension, and civic disengagement. What the Supreme Court has done, intentionally or not, is force a national conversation that can no longer be postponed. The question of who votes, how they vote, and what hoops they must clear to exercise that right is not a fringe political debate. It is the central question of what American democracy actually means in practice. Unanimity on the court does not resolve that question for the public. It does not end the disagreement between Americans who believe the system is too easily exploited and Americans who believe the system is already too hostile to participation. What it does is establish a legal foundation on which the next chapter of that debate will be built. The decisions that follow, in state legislatures, in lower federal courts, in county election offices, and ultimately in future Supreme Court cases, will determine whether this unanimous ruling becomes a genuine turning point toward clearer, fairer election law, or simply the opening move in yet another decade of litigation, legislation, and political warfare over the most fundamental act in a democracy. The court has spoken with rare unanimity. Now comes the harder part. The rest of the country has to figure out what to do with it.